Hi, everyone, and welcome to today's Startup Series program, Get Your Ducks in a Row, How Life Sciences Companies Should Prepare for IP Disputes. I know that this is a topic of major interest to many of you. We've had conversations about this, and so I'm really excited to bring in two experts today from Goodwin Procter who are going to be able to walk you through the drill, as it were. So let me introduce our speakers, and then I'm going to turn things over to them to explore this very important topic. And so first up, we've got Natasha Daughtry, who's a partner in Goodwin Procter's intellectual property litigation practice, also a member of Goodwin's Life Sciences Disputes Group. She's been at Goodwin well over a decade at this point and has significant experience in all areas of intellectual property, whether she's representing clients in hotly contested litigations or proactively guiding clients in strategies to avoid litigation altogether where that's their best strategy. Her legal practice is primarily focused on IP litigation and strategic counseling, and she focuses on patents, trademarks, and trade secrets in particular. She's experienced in guiding companies through all phases of IP litigation, from the initial investigation that you're going to do and you're going to learn a little bit about today, all the way to bench or jury trial and appeal if that's where your case ends up heading. She's also very comfortable at providing invaluable counsel to clients at various stages of their life cycle, assisting with IP strategy and due diligence, which are areas that many of your companies may encounter. Natasha has a diverse portfolio of litigation experience across a wide range of courts, so both in the federal courts, International Trade Commission, and proceedings before the United States Patent and Trademark Office. She's got a technical expertise and has worked on cases spanning a wide array of technologies, pharmaceuticals and medical devices, all the way to transmissions lines, software, and cosmetics. With Natasha today is Dr. Joshua Wenger, who's a partner in Goodwin's IP litigation practice. His practice focuses on patent matters with focus in the areas of biotechnology and pharmaceuticals. Among many other activities, Josh is a regular contributor to Goodwin's Big Molecule Watch. For those of you who are operating in the biologic space, and Josh and Natasha did not ask me to say this. This is an endorsement I'm passing along based on my own experience. Goodwin has a fantastic blog focusing on biologics litigation and biologics practice. If your technology is in that area, you should be looking at this blog regularly, and I'm happy to circulate a link for that as well. So Josh is a regular contributor to that blog. I highly recommend that you check it out. So with that, I'm going to go ahead and turn things over to our speakers.
Thank you so much, Allison. And I appreciate the plug for the Big Molecule Watch blog. We're very proud of all the work that we've done on the blog. And if you want to subscribe and get our regular newsletters or posts on the blog, just let us know. We're happy to add you to the list. So let's start off. Allison already gave introductions for Josh and I. And at the end, we will have our email addresses so that if you have any questions, comments, need advice on anything related to the things we discussed today, feel free to reach out. The mandatory disclaimer that all lawyers have to give in these presentations that this is not legal advice, it's general. And if you have fact-specific inquiries, please reach out to your lawyer. Okay, so just providing a roadmap of where we're going to go today. We're going to start with pre-litigation readiness, and we're going to talk about that both from the patentee or plaintiff side and also from the defendant or accused infringer side, the things that you need to be thinking about to prepare for potential litigation. Now, before you even get to litigation, for most of you, life stage of the company that you're at right now, you're probably not going to be in litigation necessarily, but you might be sending or responding to cease and desist letters. So we'll talk about the ins and outs of those. You probably receive a lot of them and you might not know what to do, and so we'll help you figure that out. And then we're also going to talk about the fundamentals of litigation in the US. There's going to be other presentations that go into more detail on this, but we wanted to kind of set that up and preview the different ways that you can litigate in the US. So starting with pre-litigation readiness. Before we get into this, I wanted to just provide a very high-level overview of what is intellectual property. So intellectual property, it's a general term for categories of rights and intangible creations of the mind. There's four main types of IP, only two of which we're going to be talking about today. Patents are the property that protects your rights in useful inventions and discoveries. This is going to be your chemical compounds, your antibodies, your methods of treatment using those compounds, your manufacturing processes for using those compounds, your delivery devices, all of those types of things. And then there's trade secrets. Trade secrets protect commercially valuable, confidential information like business and financial plans, formulas, recipes, customer information. There's a lot of things that people choose to maintain as trade secrets or as patents. There are some benefits to going those different routes. We're not going to go into that in too much detail here, but it's important for you to just understand the differences between those. And then there's copyrights and trademarks, which we're not really going to touch on today, but it's important for you to also understand that those are other types of IP that are important to protect. And, frankly, a lot of the tips and tricks and ideas that we provide to you today will also be helpful for you in responding to litigation readiness and cease and desist letters in those areas as well, but we're just not going to be focused on that today. So let's talk a little bit more about the distinction between trade secret versus patent. This is a chart that has a lot of information. I'm not going to go through all of it, but I'm going to just highlight a few things. First of all, patent protection is based on federal law, pretty much exclusively, whereas trade secret protection is more based, there's federal law and there's state law and common law that can apply to that. The big difference substantively between patent and trade secret is that for a patent, you have to disclose it. You have to file it with the U.S. Patent and Trademark Office to get the patent. Part of the bargain that you're making with the government and with the public is that you disclose your invention and you get rights in exchange for disclosing your invention. Whereas on the trade secret, it's kind of the opposite of that. You only maintain a trade secret and the rights of that trade secret if you keep it confidential. So you do not disclose it publicly. If you do disclose it publicly, it's no longer a trade secret. The other key difference between these two, patents usually are limited to 20 years from filing. That's how long you have the exclusive rights for that, whereas trade secrets can be indefinite. And there's some trade secrets that, because they've been maintained as a secret so long, they have been in force for decades and decades and decades. Some of the most notable trade secrets are how to make Coca-Cola, like the formula for Coca-Cola, KFC spice recipe for their chicken. And so those are the key differences between trade secrets and patent. Okay, so let's go through the first kind of checklist of considerations for pre-litigation readiness. And this is going to be focused on kind of the patentee side, or the plaintiff side, which usually is the patentee, but not always. So the first thing, if you're ever considering like bringing a suit, you need to think about what's your end goal. Like if you have a win, what does that actually look like? And that's going to vary depending on the circumstances. And you need to think about this before you put a plan in place for actually pursuing litigation. Start with your end goal. So do you want an injunction, which means keeping the other side off the market altogether? Do you want damages, like money? I mean, everyone wants money, but for this particular case, is that what your end goal is? What's more valuable to you, keeping them off the market or getting damages from them? Maybe you just want them to take a license. You're not actually going to go all the way to trial and try and get a damages award. You just want to get a license from the other side, which would have some kind of, monetary exchange. There could be other competitive advantages from litigation. You obviously have to have a valid basis to ever bring a lawsuit, but lawsuits are very disruptive for organizations. They are time intensive and resource intensive. And so even just being involved in litigation, it's going to impact your company, but it's also going to impact the company that you're bringing suit against. So after you've identified kind of what your goal is, then you need to identify the IP, patents versus trade secrets. And obviously there's going to be a whole process for doing that analysis, looking at your entire portfolio, looking at the potential products you could accuse. On the trade secret side, Oftentimes, what's going to have happened is you're going to have some employee mobility going from your company to another company, and then being able to observe what that new company is doing, and maybe they took some of your trade secrets. So that's a little bit of a different investigation you would do there. Then it's really important to check all of your contracts. And Josh is going to talk about these in a little bit more detail and why this matters, but you need to review your co-development agreements, API agreements, university agreements, licenses, confidentiality agreements. And that's because the rights that you think you might have, or that you might have conveyed to others, might not necessarily be what you actually did. So before you file suit, make sure you've done a review of all of those things. Document collection. You need to have your documents, key documents at least, ready to produce early in the litigation. And not just even for production in the litigation, but so that you know what they say. You don't want to find out halfway through a case that you have some case-shattering, awful document in your possession. You want to know that in the beginning so that you can make the right decisions about whether even to bring the case. Also important to consider countersuits. If you're thinking of suing someone, it's possible that they have IP that they could countersue you on, or other claims they could bring about against you. So, just make sure that you understand the potential risks of bringing suit, and that would include any countersuits or counterclaims. I'm going to hand it off to Josh to do the rest of the checklist of considerations.
Thanks, Natasha. If you're thinking about bringing a lawsuit, another really important consideration in getting ready is to make sure that you have access to the intellectual property rights that you're considering asserting, and the people that you're going to need in order to tell your story in the context of a lawsuit. So the patents, if it's a patent case, the patents themselves, you need to make sure that you actually own those patents, and that you can prove it to the extent that's going to be necessary to convince the courts that you actually have the right to sue someone else for infringing the patent. And that involves making sure that Natasha mentioned the contracts. You need to make sure that the assignments that where you took possession of the patents are valid, and all the documentation is available. You need to make sure that you have the proper licenses if you are the licensee, and that all of the rights that you need in order to assert the patents are included in the license that you have. And if there are some situations where you can have a license and not have the right to sue someone on your own, but you can sue them if the owner of the patent is involved, and you need to make sure if that's the situation that you have their participation as well. In terms of witnesses, in any lawsuit, it's critically important that you have the people who can tell the court what happened available to you to tell that story. In patent cases, that's very often the inventor, but involves other people as well, people who worked on whatever the product is, people who worked on marketing, and a number of other roles. And you need to make sure that you have their participation, and particularly if they're no longer at your company. So very often there will be patents that a company owns, but the inventor has moved on, and you may need that inventor in order to pursue the lawsuit. And so you need to make sure that your relationship with that person is good, and that they're available if they're needed. And then and the same is true for all the other types of roles I mentioned. In the trade secret context, if there are people who were involved in generating the trade secret or maintaining its confidentiality, you may need their participation as well. And so before you can really get going on a lawsuit, you need to make sure that those people are available as you'll need them. For patent cases, you probably should take a close look to make sure that the patent is strong enough to assert it. In patent cases, typically the major areas of dispute are whether the defendant is infringing the patents, and then whether the patent is valid, meaning whether it should have been issued in the first place. And sometimes it can be quite complicated to do a careful assessment of that. Usually that should be in consultation with your lawyers, but it can take some time and some resources to do a full investigation so that you know how strong is your suit. In the course of litigation, you're going to need experts, someone who can explain to a judge or a jury what the technology is about, and why the defendant infringes, why your patent was innovative at the time, why you adequately disclosed it. And sometimes these really technical issues can be difficult for federal judges who are typically quite smart, but may not have any background at all in the area of technology that you work in, and juries who are just people from the community may not have any background either. And it's typically the experts that explain to the court or a jury what the case is about and the technology, and having good experts who can clearly convey that information is really important. And as a plaintiff, you often want to get that lined up before you get started on a lawsuit. Now, Natasha mentioned having a clear idea of what the objective of the lawsuit is. And by damages, we're referring to monetary penalties on the defendant for infringing a patent, for misappropriating a trade secret. And if your goal is to get damages, you should have a clear understanding of what damages are actually going to be available, and do an assessment of what they would be. Sometimes, lawsuits can be very expensive, and you may have a view of how much money you would be entitled to if you win, but the facts of the market that you work in, the facts of the defendant's product, and the extent of their infringement may not actually bear out to the type of damages that you're looking for, and that may mean that the lawsuit's not worth it at all. So it's important to do an assessment early to ensure that what you're expecting is actually realistic. And then finally, parties and jurisdiction. So the parties are who's involved in the lawsuit, who are the defendants, who do you need to be involved, and who are additional parties that could be involved, and whether it makes sense to include them or not. So for example, for patent infringement, you want to make sure that you know who is the party that is actually infringing your patent. If it's a trade secret case, who misappropriated, who was involved, and who do you need to target with your lawsuit? And for jurisdiction, which court should you pursue your lawsuit in? Is it a federal case? Is it a state case? There are agency tribunals within the federal government that may be places where you can bring your lawsuit, and these different jurisdictions and venues have different pros and cons. So it's important to carefully consider where you're going to sue. So flipping over to the other side as a defendant, if you think that there's a chance that you may get sued, or often it's a good idea to try to avoid a situation where that would even arise in the first place. And there's a number of ways that you can prepare for litigation as a defendant, or work to avoid litigation at all. If you're working in an area of technology where there's a lot of patents, it can be really important to make sure that you know what the patent landscape is like. What patents do your competitors have? Which parts of your business model may be nearing an area that is covered by somebody else's patent? Now, this can be a very complicated task, especially if you're working in an area where there's a lot of competition and your competitors have lots of different patents on different aspects of the field. And it's always a cost benefit analysis to know how much of this sort of diligence you want to do, because looking through other companies' patents is a time-consuming endeavor, and you'll probably need attorneys or patent agents to help you with that. And it can be expensive to be really comprehensive. So there's reducing the risk to zero may not justify the cost of a fully comprehensive patent landscape analysis. So that is an important consideration when you're thinking about how far do I want to go in making sure I understand the patent landscape. On the other side, not doing any of it may create a huge risk for your company because you don't have any idea if some core part of your business model is directly infringing a very strong patent of one of your competitors. So it's important to look into this and then make a thoughtful decision about how much you want to spend in terms of resources on getting a handle on the landscape. It's important to have your own IP, both for offensive and defensive purposes. Patents, for example, can be really useful to keep your competitors off the market, but they're also really useful as collateral leverage in case you get sued by one of your competitors. And then you can say, well, I have this other patent that's covering something you're doing. Let's just call it even, or let's work something out so that everybody can just get on with their business. And that may be the best outcome for you. And so your own IP can be used defensively in that way, in really important ways. Internal written policies regarding documentation is extremely important for litigation preparedness. Intellectual property litigation often comes down to what do the documents say? If it's a trade secret case, can you document that you obtain the information through legitimate means? Can you, or on the other hand, are there documents that are going to be really problematic if they come out in a litigation? So it's important to have really good document retention policies that are clear and written and established. And it's important to have good document hygiene. Training your personnel not to put things in documents that are going to get them in trouble later. In litigation, it's incredibly common for a case to really turn on some email that someone sent, thought nothing of at the time, and it's the only record of some critical fact that either was extremely important for the company that wrote the email to be able to prove, or on the other hand, it makes the other side's case because someone was just being careless about what they said in an email or a memo or something like that. And particularly for patent cases, having records of inventions is extremely important on both the plaintiff side and the defendant side, because if you can prove that you had the idea first, that can be really important in defending against someone else's patent. So it's really important to make sure that you have policies governing how you handle documents and what your employees are putting in documents. It's also really important to make sure that you're maintaining attorney-client privilege over your communications with your attorney. This is another issue that comes up all the time in litigation, and your communications with your attorney are only going to be privileged if you are keeping them confidential between you and your attorney. If you are opening those conversations to third parties who are not part of your company, and within that privilege, it may waive the privilege, and then the things that you say to your attorney may be exposed during litigation. And then finally, I think this kind of came through all of the things on the list. A lot of preparedness involves and requires an understanding of what is going to happen in litigation, and it can be really helpful to talk to someone who understands how these cases go and what you need to do to prepare. So having conversations with your counsel as appropriate can go a really long way to being ready. And short conversations early on in the development of your company can be extremely helpful in avoiding really big, really expensive problems down the road. So it can make a lot of sense to loop in advice of counsel early on, just to make sure that you're doing the right things, and your bases are covered. Okay, on the trade secret side, trade secret misappropriation requires that you've acquired a trade secret from someone else by improper means. And a big part of being prepared as a trade secret defendant, or hopefully to avoid being a trade secret defendant, is to make sure that you're not doing that. So if you can avoid receiving third-party confidential information carelessly or hopefully not deliberately, that is really important. And make sure that when you are receiving third-party confidential information, you have the consent of that third party, and you have documentation of that consent where that's appropriate. And make sure you understand the source of confidential information that you're bringing in. And make sure that your employees understand the obligation to only receive third-party confidential information by legitimate means. Companies get in trouble all the time because employees went out, took information from someone else, brought it into the company, and even though it wasn't at the direction of their managers, if your company ends up benefiting from the misappropriation of trade secrets by one of your employees, it can be a very expensive and damaging problem. And having policies in place to prevent that from happening is an important preventative measure. And then again, care and hiring that's critical in so many ways, but certainly in the context of preparing for and avoiding trade secret litigation, it's critical because if you can't trust your people to behave appropriately, you can run into problems, and it really emphasizes the need to make sure that you're hiring people you can trust. Keeping R&D separate from competitive intelligence is another important way to avoid trade secret problems. These are going to be different kinds of intellectual property generated by these different teams, and if your R&D teams are walled off from your competitive intelligence teams, that will help to avoid sort of tainting your R&D process with information that came from competitors, particularly in ways that will help avoid the incorporation of someone else's trade secret into your R&D program. And then finally, once again, I'm going to talk about documentation. A really good way to defend against trade secret misappropriation is to be able to show documents that show that you and your people came up with the ideas on their own and did not rely on a competitor's ideas or information that came from outside illicitly. And having that documentation available can make or break a trade secret case. So it's important to maintain those types of documents as you go. Okay, so I'm going to tell you about just a few examples of cases that illustrate some of these principles that we've been talking about. So the first one is the REGENXBIO versus Sarepta case from a couple of years ago. Sarepta is a gene therapy company that was developing a therapeutic, and they were nearing FDA approval, and they were nearing FDA approval, and they were sued by REGENXBIO, who had patents covering cultured cells that were used kind of early in the development and the manufacturing process of Sarepta's product, but weren't the patents didn't cover the product itself, but rather some tools that were, the cell cultured cells that were used in the process of making the product. Sarepta believed that they were covered by what's called the 271 safe harbor, which protects companies from claims of patent infringement over technologies that need FDA approval in order to sell them before the product is actually on the market. So if you're developing a drug, whether it's a innovative drug that's being developed for the first time, or it's a generic version of a drug that's already on the market, if what you are doing is developing information that you need to submit to FDA to get approval, those activities are protected by the safe harbor. Now, Sarepta thought that the use of these cultured cells would be protected by the safe harbor, but they ended up being sued by REGENXBIO, and court found that because the cells are not themselves the product, the safe harbor didn't apply, and the lawsuit could proceed. And this was a situation where Sarepta, was apparently caught off guard by this lawsuit and their potential liability. And by looking at the patent landscape a little more carefully, a little more thoroughly, they may have identified this issue earlier than they did, and may have been able to work around it. But as it was, it resulted in a pretty significant lawsuit. Another example is the Lonza v. Adva case, and this was a case about cell therapy companies, and Adva made bioreactors that for use in hospitals, which is an important piece of machinery for several different kinds of cell therapies. During the lawsuit, it looked like Adva was going to be enjoined from selling these instruments based on the lawsuit, which was going to have a pretty significant impact on some cell therapy companies that were relying on the availability of this piece of equipment. And the point here is you may need to look at not just your own activities and determine whether there's any risk of a patent infringement suit, but also if you have critical suppliers or partners that you're working with, potential patent liability for them may have a really serious impact on your business. So when you're doing your diligence, it can be really important to look at those pressure points as well. To illustrate the point that Natasha made earlier about the importance of being familiar with your contracts, in the Asymmetrics versus Biocare case, Asymmetrics had an exclusive license from Harvard University for commercial uses of certain diagnostic tests. But in the contract, Harvard retained key rights, including the right to use it was a patent on an antibody for use in diagnostic tests. And Harvard retained key rights, including the right to use the antibodies for academic research. They retained the right to grant licenses to other nonprofits for academic research. And they had the right to join any infringement suit or bring their own suit. And these are key rights when courts decide who has the right to sue for infringement of a particular patent. And ultimately, the court where in which Asymmetrics sued BioCare for infringement of this patent decided that the lawsuit couldn't proceed without Harvard's participation. And that was problematic for Asymmetrics. And, depending on the particular circumstances, you may need the participation of a licensor or another party that is unwilling to participate, or who has a relationship with your potential defendant. And so the point is that because Asymmetrics didn't have a full understanding of its licensing contract, its lawsuit was unsuccessful. And then, in another example of how the details of your contracts can impact a lawsuit, in the Medicines Company versus Aspira case, the Medicines Company had developed a improved manufacturing process for a particular drug compound. And over the years of the development, they had worked with a couple of different contract research organizations and contract manufacturers to work on this compound. And it turned out that because of the way their contract with one of these suppliers was structured, under the rules of U.S. patent law, the use of this manufacturing process that they were seeking to patent was found to have been sold prior to the time when they filed for the patent, and that was a basis for the patent being invalid. And it really was based on how their contractual relationship with their supplier was structured that led to them not having the patent rights that they thought they had. So again, it's important to understand the terms of your contracts and to talk about those terms with your IP counsel to make sure that they're not causing problems. And then the last example I'm going to talk about illustrates the importance of knowing who your partners are. In Fate Therapeutics versus Shoreline Biosciences, this was a patent infringement case, or it started out as a patent infringement case, where it devolved into a trade secret case where the plaintiff accused one of its scientific advisors of taking technology from the company and then starting their own company based on information and secrets they had obtained from the plaintiff, unbeknownst to the other founders of the new company. So I think both the plaintiff and the defendant in this case were caught off guard by the behavior of one individual, and it really goes to emphasize the importance of knowing who your partners are and making sure that you can trust them and that they're adequately vetted.
Great, thanks, Josh. So next we're going to turn to a situation that you probably are going to deal with more frequently, hopefully, than actual litigation, which is sending and responding to cease and desist letters. So let's start with, you're thinking of sending a cease and desist letter. In a lot of ways, it's similar to where we started with when you're preparing to file a lawsuit. Start with your goals. What are you trying to do here? Do you just want the recipient to take a license to the patent? Are you trying to set up a paper trail or invoke a period of notice for damages down the road in a litigation? And we'll talk about what's required of that. Are you trying to get them to change course and do a design around, or maybe just make them think twice? Maybe you're not sure what your end goal is, but you just need to think about that before you get to your letter writing campaign. Consider the timing. We'll talk about this in more detail, but the notice letter can set the time frame for damages to begin accruing, and even for causes of certain types of infringement to begin. So we'll talk a little bit about that. You need to think about the level of detail, and this matters a lot because the sending of a cease and desist letter can actually cause you to be sued. So how much detail you put in there really does matter in terms of exposing yourself to risk. So talking about that risk, so if there is it's called a substantial case or controversy between two parties, that's a legal term. Someone that's being accused of patent infringement or trade secret misappropriation, they can file a declaratory judgment action asserting that the patent's not infringed, invalid, unenforceable, or they could say we didn't steal their trade secret, or what we have is not a trade secret. So you may be sending a letter to someone to say, hey, these are my rights, stay off my rights, or I'm going to sue you. And in response, you might get sued where they say, hey, there's a case or controversy between us, let's duke it out in the courts. So courts do this, it's called the all the circumstances test to determine whether there is a substantial case or controversy. And they're going to look to the strength of any threatening language in your letters or emails, whatever they are. What level of detail of infringement analysis did you put in the letter? Did the patentees have a deadline to respond? Was there prior litigation between the parties? Has the patentee had a history of enforcement? Did the letter identify specific infringing products? And did the patentee's threats cause the recipient to change their behavior? So it's a very fact-specific inquiry. And this is why it's important to get your in-house counsel or outside counsel involved in these discussions. You don't want to have, for example, a business person at your company sending out bunch of cease and desist letters to everyone and not realizing the potential implications of that. So the takeaway is be careful what you put in your cease and desist letters. There are benefits to sending those, but there are also potential risks to it. And one other thing to note that's not on the slide, but anything you put in writing and share with a third party could be used against you later. So be careful about how you're characterizing your IP, or what the patent covers, or what the accused infringing product does, because later in a litigation, if you need to change your strategy in that regard, that admission can be used against you. So just to give you some more concrete examples, so notice letters that did confer declaratory judgment jurisdiction, which means someone that was accused of infringement then sued the patentee saying, courts, we want you to decide whether we infringe this patent and whether this patent is valid. And the court said, yep, we're going to hear this lawsuit. So letters that explicitly threatened litigation unless the recipient stopped doing the infringing conduct, that was found sufficient. If the letter said that you're likely selling other infringing products in the US and warned that, we're the patent holder, we enforce our IP, that was sufficient. In one case, there were two letters that were sent back and forth between the parties. The first letter just identified patents and products, like, here's these patents, we see you have these products, but it didn't even make the connection between infringement or identify specific claims that were infringed or had claim charts or anything like that. The second letter rejected the recipient's offer of a 120-day standstill where neither party would sue. So just between those two letters, the court said there's a substantial case or controversy here, even though neither of the letters had a specific statement of infringement. And, in one case, the cease and desist letter said, we have no plans to sue you, but it had other indications that there was a substantial case or controversy. So you can't make really strong threats of infringement and say, you better change your product, but we're not going to sue you, and think, oh, that gets me out of potentially being sued myself. So notice letters that did not confer declaratory judgment jurisdiction. If you just say, here's a patent, we see that you have this product line. Without more, that did not confer jurisdiction. Letters that are framed as information gathering requests rather than an assertion of rights have also been found not to confer declaratory judgment jurisdiction. And then offering a license without any additional threats or demands did not confer declaratory judgment jurisdiction. So those are just kind of some examples. Again, it's very fact specific, this inquiry. So I would say talk to a lawyer before you send one of these.
All right, thanks, Natasha. So a lot of people think about cease and desist letters as primarily being about trying to get the recipient to stop doing something that you don't want them to do, but they also have an important notice function of putting other parties on notice of your intellectual property rights that can be important for establishing certain types of claims in an eventual litigation or in a settlement negotiation or a licensing negotiation. One of them is the entitlement to pre-suit damages for your patent. So if you are selling a product and it's covered by one of your patents, you can be entitled to damages that for infringement beginning before the lawsuit occurs if the public is on notice that you have this patent and the product is covered by it. And that requires that requires notice to the public, which can be by marking the product, and that's why on a lot of products you see patent pending or an identification of a patent number on products or on companies' websites or in other ways. But the notice can also come from actual notice to a particular defendant, which can be in the form of a communication from you to them. So you send them a letter and tell them, hey, look, I have this patent. Now you have put them on notice that they have that this patent exists, and that may entitle you to more damages if it comes down to a lawsuit. Also, certain kinds of infringement require notice of the knowledge of the patent, and that the defendant is infringing. So that comes up in the context of indirect infringement, where a defendant is responsible for the infringement of another. An example of indirect infringement that comes up a lot is where a pharmaceutical company may be responsible for the infringement of physicians and healthcare providers. For example, on a method of treatment patent that covers a way to use a drug to treat certain disorders. The pharmaceutical companies themselves are not treating patients and may not be practicing those methods, but the physicians to whom that are purchasing the drug or the patients that are purchasing the drug are the actual infringers. But pharmaceutical companies don't typically sue doctors and patients. They go after the other pharmaceutical companies. And there's indirect infringement can be the vehicle for pursuing those suits, and certain kinds of indirect infringement require that the defendant knew about the patent. So in those circumstances, it can be important to make sure that the other parties who may be using your patent have knowledge of them. And then finally, if a defendant is found to infringe a patent, and I'll get to this more on the next slide, the damages they owe can be increased if the infringement was willful, where they knew about the patent and either knew or should have known that they were infringing, and then they infringed anyways. And of course, in that circumstance, knowledge of the patent is important as well, and that can be another reason to put other people on notice of your patent rights. And to get into the willful infringement a little bit more, there's a statutory basis, based in statute, that you can, if someone you sue has been infringing your patent willfully, you can be entitled to up to 3 times the damages amount that's found. And that's an amount that will be determined by the judge, even in a case where there's a jury trial. But obviously, a threefold increase can be pretty significant. And now, threefold increase in damages is fairly uncommon and is usually reserved for really egregious conduct. But you can get an increase in the damages in any case where willfulness is found, and it can be pretty significant.
Thanks, Josh. Okay, so now we've been covering what to do kind of from the person sending a cease and desist letter, and now I want to talk about what happens when you receive a cease and desist letter. So first of all, don't ignore it. Don't, pretend that it didn't arrive. You've got to deal with it when you get one of these. And you need to evaluate it substantively. What are the assertions in the letter? What intellectual property have they identified? Patents, trade secrets, whatever it is. And if they do identify specific patents or specific trade secrets that have been allegedly misappropriated, you've got to look into the underlying facts. If it's a patent that they're asserting you're infringing, you need to see, do you infringe? Is there a non-infringement argument you have available? Maybe you think the patent's invalid. Maybe it's unenforceable for some reason. This is often when the question comes up in companies of, well, do we need to obtain an opinion of counsel? And an opinion of counsel is typically a formal written opinion outlining why the accused product doesn't infringe the patent, why the patent's invalid or unenforceable. And I can't tell you right now whether you need to obtain an opinion of counsel in response to every cease and desist letter. It's really going to be fact specific. It's oftentimes there's business considerations, the closeness of the case, importance of the product line, the size of the potential damages award, the likelihood of litigation. All of those things are going to come into play when you're determining whether you need an opinion of counsel. And it's similar to what Josh mentioned earlier, that it's a consideration of the cost of getting an opinion of counsel over how important it is for you to have that. Obviously, Josh was just talking about willfulness. Well, one of the things to prove that you didn't willfully infringe a patent is we had an opinion of counsel showing that we didn't infringe it. So there's benefits to that, but obviously cost to that as well. When you receive a cease and desist letter, it's important to know who your adversary is, who sent it. Is it a major law firm with a record of bringing successful suits? Or is it a solo practitioner who has never litigated before and you think, okay, well, based on just who sent it, they probably just want to maybe talk with us and maybe we'll pay some kind of a royalty rate, or maybe we won't pay anything and they have no intentions of really asserting this patent. So important to see who it came from. The potential options for a response, pretty broad range. You can be really aggressive, and if there's sufficient accusations and language in the letter, you can go so far as to immediately file your own declaratory judgment action to challenge that patent, whether you infringe the patent or it's invalid. There are also administrative challenges to patent validity that we're going to talk about in a minute that are less involved and expensive than full-fledged litigation, but also still quite costly. Sometimes people choose to just have a somewhat more detailed response with reasons why the IP isn't applicable. You can say, thanks for your letter, but we don't practice elements A, B, and C. So we don't infringe the patent, and have a nice day. And sometimes the letter just literally says, let's talk. And it's kind of kicking the can down the road a little bit, but maybe you just want to get on the phone. Sometimes business to business discussions are helpful to figure out, maybe there's a potential to cross license, like Josh mentioned earlier. If you have your own IP, they have their IP, you can say, let's do a cross license and be done with this. And sometimes people have responsive letters that say, thanks for your letter, we disagree. And it's essentially a go pound sand response. And sometimes people choose not to respond at all and see if there's any follow-up. This is all the different responses you can have are really going to depend on the circumstances of the case, how much money you have available. I mean, some of you that are watching this have very limited funding available to handle these issues. And so it might be that no response at all is what you need to do now until you kind of get further along in your fundraising or, your life cycle. And that's okay, as long as you understand the potential risks related to that. Okay, now Josh, why don't you take it from here?
Sure. I'm just going to give a very brief high-level overview of some of the basics of patent litigation in the US. Obviously, this is a very complex topic with lots of detail and nuance, but we're just going to hit some high points today to give you a sense. So in the United States, federal courts handle most intellectual property litigation, essentially all patent litigation. There are trade secret cases that are litigated in state court, but patent law is governed by federal law, and the primary venue is in federal court. And there are federal courts all throughout the country, and there are rules governing where you can bring a suit depending on where the defendant is located, where the infringement occurred. So there are a number of considerations that you would need to discuss with your litigation attorneys to decide where is the most appropriate place if you want to bring a standard patent infringement suit in federal court. But that's the primary venue. There's also the Patent Trial and Appeal Board, which is a part of the U.S. Patent and Trademark Office. It is a tribunal that can decide about the validity of a patent. So you can bring as a defendant, or if you think that you may be sued for patent infringement, or you have been recently sued for patent infringement, you can challenge the patent in front of the PTAB and try to have the patent found invalid, which can short circuit the litigation. One advantage of that course of action is it can be a little bit quicker than litigation in federal courts, and sometimes a case in federal court will be put on hold while the PTAB hears a challenge to the patent. And then finally, there is the International Trade Commission, which handles disputes about unfair practices relating to importation of goods, and including in the context of patents, where if you believe that someone is importing a infringing good from abroad or is using a patented manufacturing method and importing resulting products, or is misappropriating trade secrets, and part of their misappropriation is importation, you can bring a case in the ITC. The only remedy that is available from the ITC is that they can block importation of whatever the infringing good is. So if you're looking for monetary damages, this is not the right venue for you, but it can be an extremely potent weapon against a competitor if blocking importation is going to disrupt their activities. So that's another venue to consider. Again, each of these venues have unique advantages and disadvantages and unique rules, and are different in terms of what the remedy available is. So it's important to think carefully and get advice from counsel when deciding what to do. And then on this slide, just very high level summary of what is going to happen if you bring a lawsuit or if you get sued. Litigation in federal court has a number of stages. The first is the pleading stage, where the plaintiff files a complaint that says, here's why I'm entitled to some relief from the court. It lays out some of the basic facts and the accusations against the defendant. And then the defendant has to respond and say either, there's some of these things you're saying are true, some of them are not true. Here's why I don't think that you're entitled to any relief. Then once the case starts, the court will typically enter a schedule and fact discovery begins. And that's where the parties exchange information relevant to the lawsuit. And this can be a very onerous process. In some cases, it's simple and straightforward, but very often, particularly in patent cases, it's quite involved. Each party can ask the other side for documents and are entitled to get them as long as they're sufficiently related to the case. And that's something to really consider when you're thinking about bringing a lawsuit. It subjects you to discovery requests from the other side and an obligation to provide the defendant with a lot of information, which can be quite onerous and sometimes uncomfortable. Fact discovery also involves depositions of relevant witnesses, which again can be uncomfortable, but it's an important part of the information exchange. In patent cases, particularly, expert discovery is critically important, and this is a stage of the case where both sides disclose to the other side what their experts are planning to say in the event of an eventual trial. And so it involves working with experts, developing their theories for, in a patent case, why the defendant infringes, why the defendant doesn't infringe, why the patent is valid, responses to the other side's arguments, all the things that experts may need to say at trial to prove your side of the case will need to be developed during expert discovery. And then finally, a trial. Some patent cases are heard before a jury, some are heard by a judge, and the rules for that depend on the circumstances. But the trial is the culmination of a patent case. And typically, a patent case in federal court in the United States can be as fast as 18 months, very occasionally faster than that, but that's quite fast. But they can also, take a number of years. 3-4 years is really not uncommon for a patent case. Some of the other venues I mentioned on an earlier slide are faster than that. The ITC is well known for being extremely fast, which is, depending on the circumstances, may be a real benefit. So that's another consideration when thinking about litigation.
And just to bring it back to one of the things that we said early in the case about your litigation checklist and things to consider in that fact discovery phase that Josh was talking about, you may have to produce, in some cases, like every email, every Slack message, every Teams message related to development of a product. And so it's really important to have that good document hygiene, good practices, training your people to not say things in those kind of more casual, messaging apps, things like, oh no, we infringed this patent, or man, our patents are terrible. You don't want to have people saying that because it will get disclosed later and someone will be kicking themselves. Okay, so just wrapping things up, key takeaways. It's important to be prepared for this possibility. In the life science space, there is a lot of pre-litigation and litigation, unfortunately. For a lot of life science companies, their IP is their most valuable asset. or at least one of their most valuable assets. And because it's so valuable, that means people are willing to enforce it. And threats of litigation, depending on what part of your company it's targeting or where it is in your life cycle, it can be incredibly disruptive and sometimes even fatal. So having an understanding of the different enforcement mechanisms, how to defend yourself against enforcement is really important. And, one of the things that I do most in my practice is counseling clients on how to avoid litigation. I mean, I'm an IP litigator, but a lot of what we do is helping people avoid litigation, which is sometimes better than winning at trial, is to not have the litigation and get the outcome you want. Josh, do you have anything to add on conclusions?
I'll just reiterate the importance of getting advice about your specific case if you think you have an issue, and doing that early rather than waiting for a problem to snowball can go a long way to reducing the impact of these types of disputes. I think Natasha was alluding to that, but there's a lot of circumstances in which you can deal with a small problem early or a big problem later.
That's great advice, Josh. So thank you for joining us. Our emails are on the slide, ndaughtry@goodwinlaw.com and jwanger@goodwinlaw.com. Reach out by email. You can connect with us on LinkedIn, and it was a pleasure to talk with you today.
I want to thank you both so much for a really insightful and helpful program as our startup companies are venturing into the wild legal world that we spend a lot of time thinking about. I think you both did a terrific job of distilling really important key takeaways for our audience. I really want to thank you for the outstanding presentation. To our audience, thank you so much for joining us, and we really look forward to seeing you at our next program.